I'm assuming everyone can see that. If not, please just yell out. So this CLE is going to be on the recent reforms to the Residential Tenancies Act. They came into effect on the 2nd of January 2024. Before we fully get started, I just want to acknowledge that we are coming to you from stolen Larrakia land, and that sovereignty obviously was never ceded. And I want to just acknowledge any First Nations people who are joining us today, and pay respects to our elders, past, present, and emerging. All right, so we've got a fair bit to get through, and I've kind of bolded the areas of reform that are kind of more significant, that we might spend a bit more time on, but we'll hopefully get a chance to go over everything. If for time constraint reasons, I need to kind of skip over something and not go into the level of detail you'd like, feel free to reach out to Taz generally for some clarification, or if you've got any issues in particular, or if they're your issues or an issue of your client, we're very able to listen to them and respond when we can. So, sorry, just to give a bit of a sense, we'll be starting off with domestic and family violence protections, clarification around what tenants can be asked to pay, around locks and security devices, a new process for making security modifications, new privacy protections that have come into effect, tenancy database listing protections, termination notice periods being extended, and some kind of miscellaneous stuff towards the end. So the domestic and family violence changes, there's roughly 3 of them and then a few other minor changes. The first one being there's now a set process for tenants establishing the experience of domestic violence, which they can then use to rely on the other protections in the Act. So I'll go into it more detail. There's been some changes to the vicarious liability provision, which I'll also go into, and a new ability to terminate a tenancy due to domestic violence. And as those other changes come up, I will go into them as they arise. So the new process for establishing the experience of domestic violence was the rationale behind it is to avoid tenants having to re-explain their experience or justify it to a landlord or a real estate agent, knowing that that's sometimes can be quite difficult, or that relationship can become quite strained. So there's a new process where on providing one of the following documents, being a court DBO, an injunction or certain injunctions under the Family Law Act, which relate to the safety of a child or a parent, or a certificate in the approved form, providing any of those documents to the landlord or the tribunal satisfies or is conclusive evidence that someone has experienced domestic violence. And that's fairly clear in the Act. You can see subsection 2 conclusively establishes that the tenant or another occupant has experienced DV. So in some instances, a tenant will have the court DBO or an injunction potentially. In others where, it could just be a new situation or it's never been formalized to the point of the DBO, we might need to be relying on this last document, the certificate in the approved form. And that is, the approved form is now the form RT014, certificate establishing the experience of domestic violence. And that is a form that can be filled out by a tenant making the declaration that what they've told the person is true, and signed off by someone who is in a prescribed occupation, which includes health practitioners, social workers, police officers, lawyers, or a person in charge of a DV support service. So that's a pretty broad range of occupations, obviously people working in the field relevant to DV or that touch upon DV. And it's really, really helpful for tenants to not have to go down formal legal avenues if they're being supported by a DV service, they can just get it, get someone who's working there to sign off on it, and then that is their evidence that they can then use to rely on the other protections. So we've had really good experiences using this section so far, or using this form so far, and it's really simplified the processes for people who are experiencing DV. So the next major change is a replacement of the existing vicarious liability provisions. So vicarious liability is the idea that as a tenant, you are liable for the people that you allow to come onto your tenancy and for any damage they cause or you permit them to cause. There's an exception for this in the case of damage caused by someone carrying out an act of DV. The most recent change is that it's now just been simplified to, one, improve the language of it. So as I've set up there, it removes the previous wording of the number of times an act of domestic violence has been performed as a consideration for whether someone should be responsible for an act of DV. And it's just replaced it with the consistent language of because the tenant or another occupant has experienced DV. So there's, I guess, less subjectivity as to looking at, is this more likely to have occurred because, DV, this is a once-off or that sort of stuff. And it's just whether there's that conclusive evidence in the form of one of those documents. The second major change on the vicarious liability exception is that the process for a landlord bringing a claim against the person who's carried out the damage is now being clarified. So this is a really helpful thing to point landlords or real estate agents to when they're saying, but what can we do? What does a landlord get out of this? It's now very clear in the Act that the landlord can bring a claim against the perpetrator either through the NTCAT or through the local court, depending on how much money they're willing to claim. The last major change in relation to DV protections is the ability for tenants to terminate their tenancy, or if they're a co-tenant, to terminate their interest in the tenancy if they've experienced domestic violence. So this is where a tenant will, as set out in the diagram on the right-hand side, just the basic process for what a tenant needs to do in order to terminate their tenancy. So like normal terminations, you need to give a written notice. The relevant form is a RT06A, and accompanied by that form, they need to give one of those three documents that establish the experience of domestic violence. So in our recent experience, it's been giving the RT06A along with that RT14 certificate. And that's enough to give to the landlord to terminate your interest. If the person's a sole tenant, so they're the only person on the tenancy, that's enough. If there's other people on the tenancy, the tenant needs to give an RT06A to RT06B to the co-tenant along with the document establishing DV. And that's really just to give that person a formal notice that, hey, my interest is coming to an end on this tenancy as of this date. And then that person has a 7-day period to also give a termination notice, which is an RT06C, to the landlord to say that their interest will also be coming to an end. And I guess the rationale behind that is if you're previously a co-tenant, one tenant's now being taken off the lease, you will be liable, or that person will be liable for all of the rent. And it's a way for them to say, yeah, I need to also end my tenancy here because I won't be able to afford that, for example. So the Act states that if this process is followed, that the tenant who's terminating their tenancy due to DV not liable for anything after the termination date, but are liable for anything that happened before. And there is a process for a landlord or a co-tenant applying to the tribunal to get a sense of the rights and liabilities before the termination of the tenancy. All of these forms are available off of NT Consumer Affairs website, and they've also got some of their own flowcharts and fact sheets on this as well. And also just to clarify that the determination can be of immediate effect. It doesn't, you don't have to give any notice period. So it can be of immediate effect or at a date set out in the notice. All right, so the next major change, or one of the next reforms, is a clarification regarding what tenants can be asked or ordered to pay. We're looking at what tenants can be asked to pay on this slide. And it's generally just a tidy up of the existing provisions around what landlords can ask for. So previously it was spread out over a few different sections, and now it's just been clarified into one section saying what a landlord can, explicitly setting out that a landlord can only require or accept payment of rent, bond, and other amounts that are expressly permitted or required under the Act. And it importantly also removes some sections on liquidated damages, which lease break fees or clauses would come into. So it's just a general tidy up and making it really, really clear on what tenants can be asked to pay or expected to pay. The second clarification or new change, I guess, is the prohibition on rent bidding. So this is a new section entirely, and it basically prohibits a landlord from offering or advertising a tenancy and then either of their own volition or at a tenant's suggestion, putting up the rent or putting up that asking price because they've received a lot of offers. So a landlord cannot require or accept rent that is higher than the fixed amount. The exception to this would be if the original terms and conditions changed, so there was new offerings under the tenancy. So if there was gardening services, that's the example that we use and that's used in the Act, that weren't part of the initial offer, and the additional amount is reasonable and proportionate to whatever else is being offered. That's when the rent can go up or the asking price can be increased. But other than that, if a landlord is wanting to, say a landlord has put their tenancy for rent, they've gotten a lot of offers from people at a higher rate, they're unable to accept those offers and they have to withdraw the premises entirely from the market for a month before they can be listed at that higher rate. So that's intended to avoid landlords just, immediately withdrawing it and then putting it back up. And in order to get around this section, they've got to wait out a month before they relist it. And this is a really big change and a really much needed change because it's something that we see very often. People, seeing that their rent has gone up or the advertising price has gone up, by $100 or so in the space of a day or two once something's been put onto the market. In terms of the compliance and actually enforcing it, that's something that kind of remains to be seen. How Consumer Affairs, who are the relevant regulatory body, go about enforcing that, we'll have to wait and see. Now, this is a clarification for what tenants can be ordered to pay, and it relates to lease break compensation. So this is a pretty big change as well, and it basically introduces a cap on the amount of compensation that a landlord can claim and the tribunal can order for the loss of rent due to a lease break. So where there's been a lease break, if the tenancy has if there's been more than half of the tenancy has elapsed, so say a 12-month tenancy, 7 months in, a tenant can only be asked to pay 14 days rent. If less than half of the tenancy has elapsed, they can be asked to pay, or they can be ordered to pay 28 days rent. And this is all, there's often negotiations around lease break fees. And I guess the one thing that we generally have to clarify, or one of the major things we have to clarify with tenants, is that technically a landlord has to apply to the tribunal for an order for compensation due to a lease break. They can ask you to pay it outright, but technically they need to go through the tribunal process to actually establish that you've broken the lease or you've breached the tenancy agreement, and therefore there's compensation owing. And then this is just another layer of the top of that to say when there is compensation owing, these are the caps on it. So that's also, a major change that we're very happy to see now in the legislation. The next reform is around locks and security devices, and I guess security more broadly, with some changes to modifications, which we'll talk about in a second. But these are really just tidies up of existing provisions. There's an introduction of a 24-hour time limit for a landlord to provide a key where they've changed the locks or the security device. The text in purple relates to DV situations where tenants can now ask the landlord to not provide keys to a specific person because they are under a reasonable apprehension that that person will commit acts of DV against them. We're not sure how this is going to play out and how often it will be used, but it is good just that there is a process for tenants to kind of submit that formal notification to the landlord. Please do not provide keys to this person, and the landlord is unable to do that, or they're prohibited from doing that. The next change are the tenant's rights to alter locks themselves. There's now an explicit ability for a tenant to alter, remove, or add a lock or security device without the landlord's consent if they have a reasonable excuse for not doing so. The changes that are relevant to DV is that the tenant does not have to give a copy of the keys to the landlord within 2 business days, where that's the general requirement, where the landlord has committed acts of DV against the tenant or another person in the premises, and there's a reasonable belief or reasonable grounds to believe that the landlord may commit DV against the tenant or another occupant. So yeah, it remains to be seen how often this will be used, but it's good to know that it is there for these situations. And now a brand new process for the making of minor safety and security modifications. Previously, this wasn't a part of the Act, and you had to get the landlord's consent to carry out these modifications. Now there's an entire process set out in the Act for people to rely on. Generally speaking, you still need the landlord's consent, but there are, I guess, ways of disputing where the landlord hasn't given their consent or has given like unreasonable conditions, which we can get into. The general thing to remember with this is that unless it's agreed to with the landlord, the tenant has to return the property back to its original condition. The tenant can also make the safety and security modifications without the landlord's consent if they're urgently required. But if they do carry them out, they need to tell the landlord within 2 business days. A safety or security modification, sorry, I should have started with the definition. It's over on the right-hand side. It's any of the following: installation of security camera or alarm system, securing an item of furniture to a wall, or replacing window dressings, or anything similar other than a matter that relates to locks and security devices. So the process for requesting minor safety or security modifications is submitting that request to the landlord in the first instance. The landlord then has 10 business days to consider it and either grant or refuse the request. They can't unreasonably refuse to consent. If they do so, they can be seen to be consenting. The landlord can give their consent subject to reasonable conditions, and then if no response is given within 10 business days, the consent is taken to have been given. It's similar in language and in the process of an assignment, really, if people are familiar with that concept under the RTA. And in cases where the permission to carry out these modifications is refused, or they're given certain conditions which the tenant wants to object to, they can make that application to the tribunal, and the tribunal then considers whether it was a reasonable refusal, and then can basically override what the landlord has done and make their own declaration, either with new conditions or completely omitting the conditions that the landlord previously had. All right, so onto privacy protections. There's 3 new sections that have been inserted into the Act that all relate to privacy. And the first one is where when a tenant is applying for a tenancy, the Commissioner of Tenancies now has the power to set out a list of documents or information that a landlord can request. And anything beyond that, a landlord is prohibited for asking for, and there is, it's an offence worthy of 20 penalty units if they breach that. We don't yet have the list of approved documents or information, but we understand that it's currently being worked on by Consumer Affairs. Another change with the application process is that when a tenant is unsuccessful, a landlord has to destroy any of the documents they got from the applicants within 5 business days. The next big change is a new section that basically relates to the keeping of tenant information and protecting it, accessing and correcting it, and destroying it. So the first change was protecting tenants' information. There's now a general duty on landlords to take reasonable steps to protect personal information. I guess this relates to potential data breaches and unauthorized access. The second change was accessing and correcting tenants' information. If a tenant asks for the documents that are held on file, a landlord has to provide them within 5 business days to the tenant. And if the tenant asks to either amend or remove inaccurate information or destroy an inaccurate document, a landlord has to carry that out within 28 days of the request, if it's reasonable in the circumstances. What that means, I guess we'll have to wait and see what's deemed reasonable. I can foresee that being a bit of a grey area, or whether it's conjecture between a real estate agent potentially and a tenant, but yeah, we'll see how that plays out. The last change with destroying tenants' information is now that a landlord has to destroy all information relating to a tenancy 3 years after the tenancy ends. The asterisk there is the exemption where that information or those documents are being held for a legal reason. And for all of these, there's a potential offence of 20 penalty units. The last change regarding privacy protections is a new section that limits the use of images and videos taken in a tenancy. So there's a general restriction now that without a tenant's written consent, a landlord can't publish or publicly display images or videos which either show the possession of the tenant, which could directly identify them, reveal sensitive information about them, it's valuable and would increase the risk of theft, or would be unreasonable to expect the tenant to remove or conceal for the purpose of photos being taken. The other restriction is where that image or the video would identify the tenant or another occupant who has experienced or is at risk of experiencing DV. So the process now is that a landlord has to ask the tenant for their consent to display these images or videos. A tenant has the ability to request to review those images or videos, and if they give their consent, it's the default time period is a consent of 12 months unless the tenant gives a lesser time period. All right, and kind of on a similar note around like privacy and the time limits for holding information is some new clarification around tenancy database listings. So previously, it was a bit unclear as to when a listing could be made, because the language was that if a tenant owed more than the security deposit, they could be listed. It's now been explicitly clarified. It was previously our position. It's now been clarified that a tenant can only be listed if they owe more than the security deposit where that has been found to be the case by the tribunal. So it's now very clear for landlords and real estate agents that the only time a listing can be made is where a tenant who was a tenant at the time of the breach happening has breached the agreement and has agreed in writing to the listing, or where it's gone through the tribunal and the tribunal has found that that person did breach the agreement, and because of that, they either owe more than the bond or the tribunal has ordered the termination of their tenancy. The exception for, or possible caveat for the agreeing in writing to a listing being made is where the person who the listing was made in relation to had experienced DV and was found to not be personally responsible for the breach. So that relates all the way back to the one of the topics at the start in relation to vicarious liability and exception to that where it's an active DV. The next change is that there is another change with tenancy database listings is that there's now an approved form for landlords giving notice of a database listing. Landlords generally or real estate agents generally need to give 28 days notice that a listing is being made, and there's now a form for them to do that and they have to use it. That's available on the Consumer Affairs website. It's also now a strict liability offence, which means that there's no element of intention behind it. An often used example is speeding. You don't need to intend to speed in order to be liable for speeding. So if it happens, it's an offence. Where landlords threaten to list a tenant's personal information on a database during the tenancy. And that's something we see quite a lot. So this is a really helpful section to refer to. An important thing for all of this is that these changes have retrospective application, which means they apply to database listings that are made before these changes came into effect. And they apply 3 years before these changes came into effect. So January 2021 onwards, these laws are taken to have effect. And the last dot point there is that database operators have an obligation to review their databases and remove any non-compliant entries within 3 months of commencement. So they're coming up to that deadline now where they have an obligation to have gone through, check to see that they have the relevant information that validates the making of a listing. And if they don't, they need to investigate it. And if it's found to be non-compliant, they need to take it off. So if you think that there's a listing being made that's now in breach of these laws, or there might be a client you have in mind where this could relate to, it's worth just double checking if what was previously could have passed for compliant is now a non-compliant entry and whether it should be removed. The next change is the extension of the notice periods for terminations. Now, just a general disclaimer, these only apply to tenancy agreements that are entered into after the 2nd of January. So if something was on foot for an existing tenancy prior to the 2nd of January, then these notice periods won't have to be complied with, and it'll be the previous notice periods. But for any tenancies entered into after the 2nd of January, or in the case of a periodic tenancy, or sorry, in the case of a fixed term tenancy that was in force before the 2nd of January and has now rolled over onto a periodic tenancy after the 2nd of January, these notice periods will apply. So the changes are that a landlord now has to give 60 days notice in either case of a fixed term tenancy coming to an end or a periodic tenancy being terminated. So that means that 60 days prior to the end date of a fixed term tenancy, a landlord has to give a termination notice in order for that tenancy to end in 60 days time. The notice periods for tenants remain the same, so they can give 14 days notice in either case. There's also an allowance for tenants to provide an early date of termination after they get this notice. So if you're a tenant and you've received a 60-day termination notice for either fixed term or periodic, you can, if you find a place earlier, you can give an earlier date of termination. So okay, well now I'm going to be moving out on this day. And so just to note that this change is one that we called for last year. We've been calling for a while now, and it is one of the major changes that brings the territory up into line with other jurisdictions. when we don't have the longest notice periods, but we used to have by far the shortest notice period. So this is a really welcome change. And it makes a world of difference for tenants, particularly with fixed term tenancies where you get 2 weeks notice and then you got to be out. So now there's a lot more wiggle room and a bigger buffer for people to know what's happening with their tenancy and to try and look for someplace else if their tenancy will be coming to an end in 60 days' time. The other minor amendments that have been made, well, not exactly minor in the case of both of them. The first one being the expansion of the definition of undue hardship. It now explicitly includes financial hardship and the risk to physical, psychological, or mental health or to safety. So this definition falls under an application by a tenant or a landlord to end their tenancy due to hardship. It used to be the case, or it's previously our experience, going to the tribunal arguing for a tenancy to come to an end due to hardship. The tribunal has explicitly, more or less explicitly said that financial hardship doesn't cut it. Tenants should kind of know what they're in for when they're entering into a tenancy, and things like loss of employment, they can be foreseeable. So this is probably in response to that from the government to say, no, actually that is one of the categories of undue hardship, and that can be a reason for ending a tenancy under that section. The next big change is the allowance for electronic services of notices under the Act. So previously, it was just that you had to either give it in person or by post. And this wasn't complied with a lot of the time, but it only really came up when you were at the tribunal and arguing whether a notice was valid or not. But now there's clarity for everyone under the Act that you can give notices, so termination notice, an RT08, which is an intention to withhold a bond, all those sorts of documents you can now give via electronic communication, which is essentially emails. And the note for that is that it has to be in accordance with the Electronic Transactions Act, which basically the main requirement under that act is that the other party have consented to receive notices of the type via electronic communication. And that's generally for the tenancy agreements that we see. There's generally a section on whether tenants consent to, a landlord consents to receive communication by email or text or post, and they can tick a box. So that's just a thing to double check that that's there, or if there's been previous communication via email, that could satisfy that requirement. But yeah, that's a really welcomed improvement as well, because most of the time these things are happening via email anyway. And I think we might be nearing the end. Yes, so this is just a plug for our website, where we've got some tenancy fact sheets, and a plug for our service generally, that we're, at least for the Tenants Advice Service, we're a free territory-wide service that helps people, predominantly tenants, but people living in a variety of other accommodation styles. And we're just to flag that we are in the process of updating our tenancy fact sheet. So if you do come across something and it's not consistent with what I've just told you, rest assured we're working on updating those as soon as possible. And finally, on a last point, we are running a Make Renting Fair campaign, Make Renting Fair in the NT. We previously run a Make Renting Fair Safe and Certain a few years back, and kind of rebranded. We've got a few different asks now because some of the things that we're calling for have now been reformed essentially. So we're just in this process of getting compiling the experience of renting in the territory to inform or to give more detail to the asks that we've currently got. Some of the central ones, or the main obvious one, is asking for a rental bond board. So that one's pretty huge, but there's a variety of other things that the territory is still lagging behind in, and that we will be kind of formalising and putting out something to the public about what those specific asks are. But if you have experience of renting in the territory, we'd love to hear, we'd love to get your opinion on how renting is for you and the various issues or potential good experiences. There are some that you've had in your renting experience. So if you've not already done it, please complete the survey, and we'd be really appreciative of that. And I think that brings us to the end. I think this is our final slide. If there's any questions, happy to have a chat. I'll just stop sharing the screen so we can get to that. But if anyone has any questions, please feel free to yell them out or put them in the chat if you prefer.
Hi, it's Larissa from St Vincent de Paul. Can I just ask, with the DV stuff, if the victim or the protected person wants to stay and remove the perpetrator from the lease, do they still have to go to local court to do that, or does that DVO now give the power for the real estate or the tribunal to remove them from the lease?
Yeah, so the change that's happened is only when a tenant is wanting to take themselves off the lease. Unfortunately, it doesn't go that far. So what you've said is correct. They'd still have to go through the DVO process of getting the local court to order that the tenancy agreement be amended.
So with the request for the landlord not handing over keys, what if that person is a co-tenant?
It wouldn't apply in that situation. But I can double check, but my understanding is that it wouldn't apply for that situation.
Okay, all right, thank you.
Nice. We've got a question from Jules. Do the domestic family violence protections and ability to terminate a lease under Section 92A apply to leases which were signed before the 2nd of January 2024? Our position is that they do. And given the wording of the Act, that it's and the intention behind it, that it's to have immediate effect. There's no transitional provisions preventing that commencement as there is for the notice period. So we've also received some confirmation, informal confirmation from Consumer Affairs that that's also their interpretation. We take them to apply to tenancies that were signed before that date, provided that the domestic violence is occurring. And we've got a question from Christine with the R206B form. The tenant is required to serve any co-tenants. Is there an exception or alternative if the co-tenant is the perpetrator? It's not explicitly provided for, and that is something that we've kind of come across and been slightly confused by, given the purpose of the broader provision to get someone out of that situation. There isn't an exception to it, but service can be affected by someone else acting on behalf of that person. So that there is a way around it. But in terms of that person having to still give the notice, they do need to do that. There are, I guess, some practical things that you can implement for the safety of the person who is having to give the notice, like giving a business address, or if someone's doing it on behalf of someone else, giving the address of that organisation, care of that person instead of providing their new address. So that there's some protections around that, or some ways around that, but that there are no specific exceptions. The question from Jess, the question from Sabine, do tenants also have to give 60 days notice? No, they need to give the same 14 days notice. Question from Jess is, if someone just found out they're in a database, however, did not have any ideas before applying for a property, what is the process for getting the listing reviewed? So there is an obligation under the Tenancy Act, and it predates these recent changes, that once a landlord becomes aware that a listing is inaccurate, incomplete, or incorrect, that they have an obligation to inform the tenancy database and for them to remove it. And there are time limits around when they have to do that. Now, that's not followed all of the time, but generally we find that a stern email to a real estate or a landlord saying, you could be in breach of the legislation here, can usually trigger that process to occur. But there's some question marks around the transparency of that process generally. And usually tenancy data, we don't have the most positive experiences with tenancy databases, the type of business they're in. And we found ticker in particular to be a bit difficult in communicating with. The process that we've found is that you have to provide communication, or you have to post them a letter rather than being able to send them an email. That information is just not available on their website. But if there's specific questions that I haven't addressed there, Jess, feel free to give us a call or send us an email, and we can try and clarify things further. James Mathery, for electronic service, if they is included in the lease, does that suffice, or do you have to seek consent every time you have to serve? Now, if it's included in the lease, that if they've given consent to receive notices via electronic service or communication, then that is sufficient. And there's usually, for the standard tenancy agreements that we see often, which are developed by the REI-NT, there is a section in that agreement that outlines whether people are consenting or not.
Hi, it's Vicky from Anglicare here, NT. Just asking about leases that are renewed. So it's been running for a while, and then there's a renewal of the lease. Does that still form under do the extra days or the changes to the days of termination fall? Are they able to be sort of used in that situation, or is it just like brand new leases, like fixed terms?
Our position on that would be, it would depend. It could depend on the. Actually, no, it wouldn't at all. If a new agreement is signed, like it doesn't have to be, someone else moving in, but if a new agreement signed for a new set period, that would be a new fixed term agreement, and that would, if it's after the 2nd of January, they'd have to provide the 60 days notice. And then the other example is where you're on a fixed term tenancy and that's now rolled over to a periodic. If it rolled over to a periodic after the 2nd of January, the 60 days will apply to. I'm mindful that we've got about 10 minutes left, and if there's no further questions, we might want to wrap it up there, unless people are conscious of getting a full CPD point. If there's no objections though, or no further questions, I think we might bring this to a close. So if there's anything else, I'll give just a few, like another minute or so for people to pop something in the chat. Question from Sabine. So after landlord terminates, the tenant can terminate within 14 days. I have to double check on the termination period. I believe that is correct.
Yeah, I would say it's probably correct for a periodic tenancy, because that notice period is 14 days, and because there's no end fixed date. But I think I would be of the view that if it's a fixed term lease that ends, for example, on the 30th of May, if you've given the 60 days notice and the tenant gets notice within that period, I don't think it would be valid, and they'd have to be on to the end of the fixed term. Is that how you would understand it, Al?
Yeah, I think the question was in relation to when, the landlord has given that determination notice and there's the ability for the tenant to come in earlier and give, so that they're removed from the tenancy earlier if they find somewhere else to move into. I've not got I just don't want to give out, inaccurate information. So Sabine, if you don't mind, I can clarify that, to you offline and potentially to others, who are interested, if we can send a follow-up email on that. But I'll take note of that question. We've got a question from Shane. Do you consider notice to be effective by email if sent to the tenant's lawyer where it's not provided for in the lease? I think our position, for example, Shane's question continues. For example, lease states physical address and tenant later is legally represented and notice is then sent to the lawyer by email. That's a great question, Shane. Just rereading it. I guess it would depend on the exact situation and what had been communicated to the person giving the notice. So if it's clear that the tenant is consenting to service to the lawyer, that would be just my basic assumption, but I would want to clarify that with reference to the Electronic Services Communication Act. Sorry, that didn't answer either of those last two questions, but I can clarify for both Shane and Sabine regarding electronic service and Sabine on the notice period. Thanks, Shane. All right, I think we'll call it there. Thank you, everybody, for your attendance and for your participation in asking some questions. I'll get back to you on those answers, like I said. And if there's anything else that comes to mind that you've got any niggling concerns about or queries, we're happy to clarify them to you offline, or by another CLE, if that's what your organisation wants, assuming that most people here working in this space. Yeah, we're happy to come out and do a targeted CLE if that's what people are after.
Lovely. Thank you.
All good. See ya.